afternoon, and welcome to IAB There, our daily live stream in which we connect on all things in the digital ad ecosystem. I am Michael Hahn, EVP and General Counsel of the IAB. I'm happy to welcome to the show today Anders Pilgaard Andersen, SVP and General Counsel, and Elena Turtinu, VP of Legal and Policy at Adform. Thank you both very much for joining us today. And we're going to have a fantastic discussion on privacy issues. So welcome, and let's dive in.
Thanks, Michael.
Thank you, Michael.
We look forward to it. It's going to be fun.
All right. Well, before we jump into some of the meaty details that really are central to the way our industry is evolving in the US and Europe around privacy, let's start with Adform. Can you tell us a bit about the company, its business model, and its geographic reach?
Yeah, of course, Michael, and we're very happy to be here today. Adform is originally, as it also says on top of my head here, we're out of Copenhagen, Scandinavia, originally, more than 20 years ago. Three guys in a basement decided to start in this fairly new space at that point in time. But today we've evolved. We're in close to 30 markets with companies across the world, also in the US, of course. We've been around for quite some time. And we're very proud that we have a full stack platform technology helping advertisers, agencies, and publishers alike across the world, ultimately speaking. I think more or less we serve ads everywhere globally. And one of our things that we're very proud of is that we have a very transparent approach to the ecosystem and to helping our clients in that regard. So transparency is something that means a lot to us and always has. And in addition to that, being from Europe, we got hit by GDPR, good or bad, pretty early on. So we have this privacy by default kind of built into the platform simply because that is who we are and it is what we would like to do. So in that respect, we don't have what you can say is traditionally named as true private information. We don't have names, we don't have emails, we don't have credit card information in that regard. We're based on the more anonymous identifiers out there, and that's something we're very proud of.
Fantastic. Well, with that background in mind, so being an important participant in the digital ad marketplace, you must take a look at this privacy landscape and see that there are opportunities out there, just even based on privacy. So there are a number of participants who are doing a variety of different things. First-party data is becoming increasingly important. We see different positioning around the deprecation of the third-party cookie. From your vantage point, what are the biggest opportunities you see for your company and perhaps even more broadly for the industry with the new state privacy laws?
I will take this one, Michael. So when we look at, or when I look as as privacy professional responsible to overseeing Adform's privacy compliance at the global level, one of the biggest opportunity that Adform has is through the lens of our long-standing GDPR compliance, indeed, as Anders already has pointed out. So we are 5 years ahead of our competition when we look now from the prism of expanding even more in the US market. We're 5 years ahead our competition in terms of privacy compliance. So that is when we look at it, is there have been a luggage of learnings, things that worked, things that didn't work, robust privacy compliance processes, as well as robust and solid consumers' rights. So like a portal where consumers can exercise their rights in a automated way, so privacy by default and design. And that is the opportunity that we have, and we look at it as how can we leverage that to our advertisers, to our publishers, to our prospects in the US market. now with the U.S. state's law, being enacted, we're, on the verge of being enacted. And that is why I look at this opportunity through the prism of our vendors, of our like advertisers opportunity, because now I think the advertisers in the first place, but also like publishers, similarly, they have, or equally, they should carefully choose, the vendors they work with, and because it's when we as a vendor place a pixel on a website, yeah, and that information is shared, that information is collected from a user that visit that brand website or that publisher website, and that information is collected and shared in the downstream. And with the U.S. privacy laws, being more restrictive on how that information is collected in the first place, how that information is shared in the downstream, advertisers will be are going to be held accountable on and need to review who are those vendors and what is the relationship I have to those vendors. And to give you one example where from Europe and what we've seen on the enforcement side and how did we help navigate those conversations, for example, is we've seen a variety of enforcement activities from either regulators, either from privacy activists reaching out, or consumers reaching out to clients demanding certain things. And if you as a vendor, or as a vendor, if we're not able to quickly navigate through a consumer request that our client is getting, right, then we must do something wrong. And we've successfully supported those kind of requests when an advertiser came to us and said, this is what a consumer is asking us to do, or is demanding from us. Can you help me navigate through that request? And in the with the U.S. privacy laws, being more restrictive, how can you do that? You can do that through two things. One is having a robust contractual undertaking, which between the advertisers, between all of the players within the ecosystem, because this is it's a very dynamic ecosystem. And second, through robust consumer privacy law rights, privacy portal, and then how you signal that consumer choices in the downstream.
That's great. I'd like to just dig in a little further on a couple things you said there, which I found very interesting. So first, in the first part of your response, you mentioned that from your experience in Europe, there were things that you learned that worked and didn't work. And, that's something that I'm always keenly attuned to as we think about how we deploy compliance programs, but also as we think about privacy laws and how they're propagating across different jurisdictions. One of the things we hope is that there's a learning process that we as an industry have and that legislators have as well as they look to see what has worked and what hasn't worked. So I'd love to get your thoughts about what you think with respect to GDPR and your learnings from a compliance standpoint. What worked? What didn't work?
Yeah. So what definitely worked is to be ready ahead of the competition, not go with the wind, right? Or not look necessarily on what your competitors do, how ready they are, but just take a stand tall approach and say, this is us. This is how we're going to, this is our go-to-market strategy. We put privacy at the forefront, and our compliance our compliance practice indirectly will end up with the advertisers and publishers' compliance practice. And one example is to call out here is when you navigate, and this is where the advertisers and publishers get most sensitive about. When there is a regulator, when there is a consumer knocking on their door and saying, can you show me who are the vendors that you work with? And how do you, what is the basis, the legal basis that you, for the purpose of digital advertising, because this is the space we do business. And this is when this is when the counterparty, the in-house counsel on the advertiser side, gives me a call and says and asks, can you show me whether you do transfer the data from the EU to the US? If you do so, what is the legal what is the appropriate mechanism that you have? And then and if you don't have your house into order, then it takes time to respond. It takes time to fix the problem. And then hence you risk at having a client that is getting a fine. And then, the long tail, us potentially getting into trouble too. So, this is one of the things that have worked, being ahead of the competition and being ready, and do not be afraid. This is at least, has been my approach since I started working at Adform, which was 4 years ago. Do not be afraid to be bold and to speak about your privacy practices. If you have a good product, if you have, a good, if your services are robust enough. And this is because, privacy is a sensitive topic. It's a sensitive topic per se. And, at least this is what my counterparts, like some other vendors, we don't speak about it. During controllership, we don't speak about it. Where data transfers, how do you guys do it? We do a little bit of data. If you, don't be afraid to be bold if your privacy practices are, if they're robust enough. Let's put it
and
this way.
maybe, Michael, to add a bit more from the, let's call it the legislator perspective, because I'm actually quite curious to hear what you think from the US side on that. But if I should take a European approach to that one, I think we have been, not in the beginning, it was a lot of hard work, but we're actually quite fortunate that we now, 5 years after GDPR came into effect, that we're starting to we see some trends now. We're starting to get some okay, this is how it's being interpreted. This is how we're supposed to do. There's guidance that's coming from the EDPB, which is like this board of all the data protection authorities across Europe. There we're quite lucky now that we're getting there. But if you flip that, you could say from the other angle, what didn't work is that it actually took, I believe, too long for the EDPB, for the legislator to kind of give clear guidance. What is it you expect? And, it shouldn't come from a lawyer saying that enforcement was too slow, but I actually think it is. There have been claims that have taken 3-4 years to settle. It's done outside of the court system here. It's done more administratively in the European context. And that uncertainty as a participant in the spring, be it advertisers, publishers, or a vendor in between, that's something that I would like to have seen done a bit faster, a bit more guidance, a bit more lean in, you could say, from the legislator. But I'm actually quite curious what you think on the US side here, and kind of the process you're seeing. It's a state by state business. I say lucky that we have one set of rules here. You're seeing something quite different on your side, I would say, with its different states, right? It's being implemented in different ways. So navigating that landscape is tough for any vendor, simply to keep up, I would say.
Yeah, it's a great question. Stepping back from 50,000 feet, I guess I'll make more of a global statement before talking about the US, which is about 2 years ago, we finished a project called the Cross Jurisdiction Privacy Project, where we looked at the privacy laws of 10 countries across the globe, excluding the US and Europe. And one of the things that I think most participants, myself included, began with as a baseline is that we were going to see a lot of laws that looked a lot like GDPR. And what we actually found was something quite a bit different, which was a lot of laws that were inspired by GDPR, but used their own processes, learnings from GDPR, their own cultural context and values to come up with their own privacy laws. And I do think that there's a lot to be learned and continuing to learn from these different jurisdictions. Singapore being an example of, I thought, a jurisdiction that sort of landed the plane in appropriate ways based on many of the learnings that came out of Europe. The U.S. obviously has a different cultural context around an expectation for privacy than exists for European for citizens in Europe. There's different history, different cultural context. And so we obviously have pursued a pathway that involves the opt out of personal information. I'll put aside cross context behavioral advertising and sale and all those fun distinctions for a moment, except in the case of sensitive personal information, where there are still some states like California where it's opt out, and other states where it's opt in. And so I think we're navigating our own pathway. So I think you could see some inspiration from the GDPR in the various state privacy laws, in particular when you look at the sets of rights that consumers have to delete, access, correct their data. Feels pretty close to GDPR. But you'd be hard pressed to think about an opt out of sale in the same way that you think about processing personal information, either pursuing a contract, legitimate interest, or whatever the basis is in Europe. So it looks and feels quite a bit different. One of the things too that I find really interesting in this is a lot of what you both discussed around advertisers. And when I think about some of the challenges that exist for advertisers under the new state privacy laws, it really is significant. So, and no more so than in California, where there are two very significant changes which will dramatically change the way we operate in digital advertising, in particular from the buy side. So I think about one, there's a limitation on service providers being able to engage in cross-context behavioral advertising in California, not in the other 4 states. And the second is that service providers are prohibited from combining personal information between different service provider engagements, or that they otherwise collect themselves, unless it's otherwise permitted by the regulator, which we haven't seen anything indicating that there is a set of permissible combinations that they've identified. And so that's really significant, because when you think about the CCPA compliance that has been pursued by many large advertisers, a number of them have taken the approach and are continuing to take the approach that they don't sell personal information or engage in cross-context behavioral advertising. Now, there has been a legitimate way to do that under CCPA, and there's a legitimate way to do that with the CPRA amendment to CCPA. But suddenly, now you can't upload your CRM data to your DSP any longer and say target this group as when you have a service provider relationship in place. And so you're going to now need to think about alternative ways of reaching your audience that are going to be less effective if you choose to go down this pathway. But even then, your compliance is still really a big challenge, because if you've taken that service provider approach and service providers can't combine personal information, how are you going to measure and frequency cap, right? And so those are key use cases. Obviously, when we, the IAB, worked on our industry compliance framework, the MSPA, to address those concepts, where interestingly we drew from some of the GDPR concepts around joint controllers between publishers and advertisers, designating measurement companies as joint service providers, so that combinations are not happening between different controllers for their own independent business purposes, but it becomes a unified data set that's shared. So big changes in store for advertisers, and love to get a sense from both of you what you're seeing from advertisers as they're approaching state privacy compliance.
Yeah, I love the example with the frequency capping, because there it starts, right? And this is one of the basic processing activities and the basics of the digital advertising. If you can't frequency cap, and frequency capping is, you can also do it singularly on one page and one publisher page, but in order not to annoy a user, the frequency capping is automatically cross-site. Right? Because the advertiser said, I don't want the same user to see this ad more than 5 times. So what will happen if we go on the path of ad from, let's say, we stay within the bucket of like, I don't know, we don't do cross, measurement. We don't do cross frequency capping, which means we can't serve the need of the advertiser to only frequently cap, to number 5. We could do that, but only on one digital property, only on one publisher page. So that is why this is the challenge that is the service provider or like advertiser would be facing to decide what are they doing. Are they, like which bucket, or which way should they go in terms of like compliance, because of like also the concept of the joint controllership, because suddenly they have an ad server, that communicates with the DSP and then with the SSP, with the publisher's ad server. And then they are, required to know how that is going, like who does what in the chain. And so I remember very, very well the conversation on the service provider concept when the CCPA came into force. That was extending talks where we tried to fit within the service provider bucket back then. We said, okay, we are a service provider where we are a business, do we sell? And I think now it's going to be impossible for vendors, for, for DSPs, to fit within that role. It's just, as you said, you need to measure the ads, you need to frequency cap, you need to calculate attribution, conversion. And if you're not able to do that, which is not permitted, right, under a service provider role, then this is where advertisers need to understand. And from the conversation I have right now to answer your question, Michael, is indeed the advertisers are not ready to go that path. So they say, we don't, you are a service provider for us. And you have to we go into the bilateral conversations with the advertisers to explain that, and that is not an easy conversation we have, because there are like big brands out there that say, no, it's not. And, so that is, it's quite a challenge, but, and I don't know if we will have to see or witness more enforcement. I hope not, because that is, this is when, consumers trust, it's very difficult or very hard to earn and then difficult to lose. So I hope we'll not end up into that situation.
Yeah, I just to add, and Elena almost made the point, but I do think that these discussions with advertisers and vendors leaning a bit out and kind of guiding that discussion. We saw that with first the data processing agreement in Europe, and now it's becoming into a controller and a co-controller. Here, 5 years in Europe, we're still having those discussions, and I think being able to educate and help your advertisers or publishers, for that matter, is something that will take an effort for the next time. And I don't know how long that is going to be, but that's a journey. And I don't think that's something that's going to be solved quickly. That will continue to happen when you have global brands who have a perception that's, there's risk allocation, how much are you willing to take, not willing to take, and so forth. So that definitely is something that's going to take up legal department's time going forward.
So I can maybe add a little bit on how, for example, what are some of the initiatives that, like how to deal with this kind of challenge also in Europe, because we still have a joint controllership challenge in Europe. We still have, that kind of like who is jointly controlling whose data in which context in the programmatic advertising. And what we're seeing right now is smaller circles of in-house counsels, so right now happening in local markets. They gather and they try to build up a framework that potentially is going to scale. And that framework basically sets the basic processing activities for which, like the stakeholders, the publisher, advertiser, vendor, DSP or SSP, how they share liability together. And this is what we try to scale now. So we do into small steps, and on the framework perspective, but also like in parallel developing or working on a technical concept which will encompass, so that we have, like that every vendor and every advertiser and publisher that wants to participate within the framework, then like they need to play by the rules of the game. And that is why we have people like sitting at the table, conversations with each of like representatives, legal experts from all of the stakeholder groups.
Well, that's fascinating and brings up for me one of the points I want to highlight about the divergence in the approach in GDPR versus the state privacy laws that began with CCPA. So the evolution of GDPR is this expansion of who is a joint controller. And now it's even expanded to the CNPs. The Belgian DPA said it includes IAB Europe, which is obviously something that's going to be litigated at the ECJ. So you've got this growing concept of who is a joint controller. And you can make an argument to say, well, on the one hand, that kind of puts everyone who's a joint controller with skin in the game and causes everyone to cooperate, or should cause everyone to cooperate because there's shared liability and so on. The US takes a different approach, which I'm actually kind of partial to. I really do think that this is one area where, while some of the state privacy, well, at least CCPA, while it was a little bit rushed in terms of its enactment, all happened very fast. One thing they really, I thought, got right was that it says, hey, consumers don't understand all of this. What they do know is who they have a relationship, which is the publisher or the advertiser. And it's the publisher or the advertiser as the first party who ultimately has the responsibility for effectuating the consumer rights, which isn't to say that, a consumer couldn't go to a DSP and SSP and exercise consumer rights. They can do that, but no one would know, or no one reasonably does that as a consumer. And so the locus of legal responsibility largely sits with the first parties with whom the consumer has the relationship, which is the business in California or the controller in the other states. And I think that's a fundamental departure from where GDPR has gone in sort of this joint controller context. So, love to get your thoughts on any of that.
I mean, and we still have that. So I think in Europe, that it's still the first party that, where the consumer, the page where the consumer, is right now on, is responsible, to collect the consent, or, if it's the US, and to provide an opt-out, right? What has changed with various enforcement and European Court of Justice decision is that vendors are, I'll go one step back. So previously, with the GDPR being enacted, it was sufficient for the vendors to have a contract, to have an agreement which sets the rules of the game, who is processing what, who sets a pixel on whose page, and what information is collected, what categories of data, and so on. Now, there's been a series of enforcement activities, and the regulator said, you vendors, you need to take more responsibility. You cannot just rely on the consent or on the opt-out that has been, been provided or not on the publisher or the advertiser page. Those parties, they need to signal, and you need to be evidence. You need to evidence that you have got that consent or not. And that can get a little bit more complex. But vendors are now put also into driver's seat to look into the collection practices, to look into the opt-outs of the clients, of the advertisers for whom they get the data. And that signaling, how is that signaling happening? And this is where we come into a more harmonized way of how, vendors, CMPs, advertisers and publishers, they come together to say, I signal you in the downstream the data, and I signal you what is the legal basis for that, and you are only permitted to act upon that. This is what is happening in Europe, and that conversation on the joint controllership is still, it's still a difficult one. But on the other hand, suddenly, everybody cares about who is engaged. Who is engaged in the data collection, who is engaged in data processing, and who delivers what at which stage.
Well, we are almost out of time. So final question. How do you see the privacy landscape evolving in the US and Europe?
I think if we start in Europe, I think we will continue to see some of these big decisions coming out, getting more clarity. As I mentioned earlier, I think we're starting to get there. We're starting to kind of know where to go. We have a good amount of cases now, but we will of course continue to see the Max Schrems of the world continue to push the boundaries, and that's also good to test the system a bit. On the US side, I think you're much better, Michael, to actually answer that question yourself. But at least seems from us, from a compliance perspective, being a global business here, at least I know it was on the table at some point in time to do, a federal legislation around this to get some, like, one market instead of 50 markets from an interpretation perspective. I know the MSPA is really helping on figuring out signals of the contracts as these states come with more and more legislation, you could say. But I would say that with 5 years of experience from GDPR and looking backwards in that regard, I really think that is also something that the US potentially could benefit from. I know I go into a state and federal discussion here, which is a broader one, but still, I think from an advertising perspective, from a vendor perspective, that is something that would actually benefit everyone. And from a user perspective, you could say, I think it would be great for the end users out there that, you're protected in the same way, irrespective if you live in California or Nebraska or New York or whatever it may be. So that's, that's the reflection seen from the European perspective, but of course, very keen to hear your reflections on where do you see it going on the US side.
Well, on the U.S. side, we've got, I think, another 4 states. So I continue to see that progressing. We at the IAB certainly have advocated for a preemptive federal privacy law, and the question is, what's the likelihood of that? I've long given up being able to predict this sort of thing. There seemed to be some movement last year for the first time in a long time, and then it didn't happen. And so, the question is when, what's it going to look like? I can't honestly say whether it's going to be 2 years or 20. So I just keep marching forward and taking the world as it is, which is I got to start amending the MSPA to deal with 4 other states.
And that's also plenty of work, I would say, though. So it's not that you're going home early for sure. It's a lot of work, of course, to get there.
I would like to add also a couple of things. In the EU, we have a couple of regulations coming also into effect. So we have the DMA, the Data Markets Act, and we have the Data Services Act, and they envision even more transparency on platforms such as Adform, but also like very large platforms, and I think that is a good thing. And there are some initiatives, of course, also on the artificial intelligence, and how is that going to play along, or how is that going to affect the digital marketing. I don't know, but I think like for us, GDPR is equipped like to from a like automated processing perspective, profiling, how is that, so that is already in place. And where I also see more, let's say on the good news side, is more harmonization on the on industry frameworks. For example, the transparency and consent framework, that is the IAB framework, which has been of a great tool and framework for all of the parties engaged to like that helping providing more transparency. And there will be also a more like an updated one on the TCF.
Well, terrific. That was a fantastic conversation across all things privacy in the US and Europe. Could not have asked for anything more. Anders, Elena, thanks so much for taking the time to have this discussion with me at IAB there, and look forward to talking to you again.
Thank you very much.
Thank you very much, Michael.